Hello everyone, welcome to NeoUnrealist. It looks like that day of reckoning has finally come for the first of the members of the attempted coup cabal that tried to take down Donald Trump, both before he was elected President of the United States and even after he took office. Fox News is reporting that U.S. Attorney for the District of Columbia, Jessie Liu, has recommended moving forward with charges against the former deputy and acting director of the FBI, Andrew McCabe. Now, McCabe, he was appealing Liu's decision. He went up the chain all the way up to Deputy Attorney General Jeffrey Rosen, who rejected his request. Now, McCabe's troubles, they stem from the scathing report put out by Obama-appointed Inspector General Michael Horowitz, released, last year, April of 2018. Horowitz's findings were that Andrew McCabe authorized leaks about a Hillary Clinton investigation into the Clinton Foundation, and he lied about it to investigators in order to serve his own self-interest. Fox News cited a source close to McCabe's legal team who said that they received an email from the Department of Justice that said, "The department rejected your appeal of the United States Attorney's Office decision in this matter. Any further inquiries should be directed to the United States Attorney's Office." What that means is that the way has been cleared for the imminent indictment of Andrew McCabe. One assumes that the grand jury will be called in within the next couple of weeks and the facts will be presented to them. And let us remember, those facts are very bad for Mr. McCabe. Andrew McCabe leaked the existence of the FBI's Clinton Foundation investigation. Recall that this is something his then boss James Comey was trying to keep secret, even in his testimony before Congress. That McCabe orchestrated the leak is not in question. McCabe himself concedes that. Inspector General Horowitz determined that McCabe orchestrated the leak for personal reasons, in order to counter the appearance that he was favoring Hillary Clinton because his wife received over $500,000, remember, from people like known Clinton bagman Terry McAuliffe, in order to run for some low-tier political office in Virginia. Horowitz also found that in spite of knowingly orchestrating that leak, McCabe went so far as to chastise the chiefs of the FBI's Washington and New York field offices as if they were the ones responsible for the leak about the Clinton investigation. Let me repeat that. McCabe, knowing he was the one who was behind the leak, he took to task the heads of the FBI New York and Washington field offices for what he did. How do you think that is going to look in front of when it's presented to a jury? Now, he's made it crystal clear. It's been made crystal clear, I should say, by McCabe, that if they go to court with this charge on him, his defense is more or less going to be Orange Man bad. I mean, that he's being charged because of White House pressure. And to be sure, let's not mince words. President Trump has made it no secret he has no use for Andrew McCabe. I think he calls him a dirty cop. So I guess McCabe, sure, he can make some hay with that. But that still doesn't change the facts of what he did. As I understand it, he doesn't deny what he did in terms of the leak itself. I think his defense is, as deputy director, he was authorized to speak to the press and make that leak. And that, on the other hand, he had Comey's authorization to do so. Which, by the way, James Comey, his former boss at the FBI and a fellow conspirator, denies. So we have a situation where either Andrew McCabe is lying and Comey authorized the leak, or Andrew McCabe is lying and Comey did not authorize the leak. Or I should say, or Comey's lying. But the bottom line is, both cannot be true at the same time. I mean, Comey either did or did not authorize the leak, and, one of them has to take the fall for it. So is it just me, or do you also not sense the potential there for a deal to be made? I mean, the easiest way for McCabe to make his troubles go away is to make a deal. Roll over on Comey. I mean, what's the old saying that cons have about rats? Why do 10 if you can give 5 to a friend? I mean, yeah, if it just comes down to it, I don't see Andrew McCabe risking doing time if he could just sit in a witness box and put the whole thing onto James Comey. But I don't even think he could really do that. I mean, because no one's backing up McCabe's story. No one. I just don't think he can escape the facts of the case. They went after, remember, General Michael Flynn on a lot less than what they have on McCabe. Let's examine just one of the 4 instances where the Inspector General's report says he lied. His dispute with James Comey over whether or not he told Comey about the leak to the media. OIG analysis, a lack of candor. Lack of candor is the Department of Justice's polite and legalistic way of saying he lied. Number 1, lack of candor with then-Director Comey on or around October 31st, 2016. We concluded that McCabe lacked candor during his conversation with then-Director Comey on or about October 31st, 2016, when they discussed the October 30th Wall Street Journal article. As detailed above, Comey and McCabe gave starkly conflicting accounts of this conversation. Comey said that McCabe definitely did not tell Comey that he had authorized the disclosure about the PAYDAG call. To the contrary, Comey told OIG that on or about October 31st, McCabe led him to believe in form or fashion that McCabe did not authorize the disclosure about the PAYDAG call to the Wall Street Journal. Comey described how McCabe gave Comey the impression that McCabe had not authorized the disclosure about the PAYDAG call, was not involved in the disclosure, and did not know how it happened. By contrast, McCabe asserted that he explicitly told Comey during that conversation that he authorized the disclosure, and that Comey agreed it was a, quote, good idea. You see the discrepancy there? McCabe says he told Comey. Comey says he definitely did not tell him. Moving on. While the only direct evidence regarding this McCabe-Comey conversation were the recollections of the 2 participants, there is considerable circumstantial evidence, and we concluded that the overwhelming weight of that evidence supported Comey's version of the conversation. Indeed, none of the circumstantial evidence provided support for McCabe's account of the discussion. Rather, we found that much of the available evidence undercut McCabe's claim. And here they go on to lay out their circumstantial evidence that show Comey's story holds water and McCabe's does not. First, Comey had pointedly refused to confirm the existence of the Clinton Foundation investigation in testimony to Congress just 3 months earlier. Additionally, 1 month before McCabe authorized the disclosure, Comey also refused to confirm or deny 2 different investigations during an FBI oversight hearing before the House Judiciary Committee. Comey stated during the hearing, "Our standard is we do not confirm or deny the existence of investigations." Comey noted that there is a public interest exception, but our overwhelming rule is we do not comment except in certain exceptional circumstances. Comey told us that when the FBI made disclosures of this type during his tenure, such as occurred in connection with the Clinton email and Russia investigations, it did so only after careful deliberations as to form and wording. He also noted that such a disclosure would not be made through an anonymously sourced quote given to a single reporter. We found it highly improbable that Comey would have been approving of a decision by McCabe to disclose to a reporter on background information essentially confirming the existence of an FBI investigation that Comey himself had refused to confirm when testifying before Congress. Second, on the morning after the article appeared online, and the same day it appeared in print, Comey expressed concerns at his staff meeting about the volume of leaks as evidenced by special counsel's contemporaneous notes of the meeting. We found it highly unlikely that Comey, in a discussion with McCabe that same day, would have been accepting of a disclosure authorized by McCabe that looked exactly like the type of leak that he was condemning to his staff. Third, the disclosure occurred less than 10 days before the presidential election and just 2 days after the firestorm surrounding Comey's letter to Congress after taking additional steps in the Clinton email investigation. Disclosure of the PAYDAG call risked subjecting the FBI to even more criticism about potentially affecting the imminent presidential election by confirming the existence of a previously unconfirmed criminal investigation involving candidate Clinton. We highly doubt that Comey, who himself expressed concern to us that the Wall Street Journal disclosure occurred 2 days after his October 28th letter, would have countenanced such a disclosure by McCabe within days of the election if he had been told about it. Fourth, publishing the account of the paid ad call risked further poisoning the FBI's relationship with Department of Justice leadership at a time when it was already under great strain because of, among other things, Comey's decision to notify Congress on October 28th that the FBI was taking additional steps in the Clinton email investigation and the department leadership's concern about leaks emanating from the FBI. Fifth, on October 27th, Comey and FBI General Counsel expressed concerns to McCabe about whether McCabe should participate further in the Clinton email investigation because of the appearance created by the campaign contributions to his wife's campaign. The same logic applied to the Clinton Foundation investigation. On that same date, McCabe authorized special counsel to discuss the August 12th paid ad call with the Wall Street Journal reporter, thereby confirming the FBI's criminal investigation. McCabe's text message to special counsel late on October 27th, "No decision on recusal will be made until I return and weigh in," shows that he knew the issue of recusal was clearly on the table. Indeed, McCabe announced his recusal from both Clinton-related matters on November 1st. So under these circumstances, McCabe had a strong reason not to tell Comey on October 31st that he had authorized the disclosure to the Wall Street Journal about the Clinton Foundation investigation. It would have been an admission that McCabe had taken action relating to that investigation at exactly the time that McCabe's recusal from the Clinton-related matters was under consideration by Comey. Further, we found it extremely unlikely, as McCabe now claims, that he not only told Comey about his decision to authorize the disclosure, but that Comey thought it was a good idea for McCabe to have taken this action. Sixth, no other senior FBI official corroborated McCabe's testimony that among FBI executive leadership, people knew that generally he had authorized the disclosure. Rather, multiple witnesses identified by McCabe told us that because of the information contained in the Wall Street Journal report, they did not believe it was an authorized disclosure. They also said that they heard about such an authorization. If they had heard about such an authorization, they would have recalled it because it would have been so unusual. Other than special counsel, no witness we interviewed told us that they knew that this disclosure had been authorized at the time. We think it likely that at least some FBI executives would have been aware of McCabe's authorization if he had told Comey what he had done. Finally, Comey's testimony that McCabe did not tell him that McCabe had authorized the disclosure to the Wall Street Journal is entirely consistent with McCabe's statement to INSD on May 9th that he had no idea where the disclosure came from or who the source was, as well as his claim to the OIG on July 28th that he was not aware that special counsel had disclosed the information to the Wall Street Journal. Conversely, McCabe's claim that he told Comey is not only inconsistent with his May 9th and July 28th statements to the INSD and the Office of the Inspector General, respectively, but there would be no reason for McCabe to not tell INSD and OIG about his actions on those dates if he had already admitted them to Comey. Indeed, McCabe contacted the Office of the Inspector General on August 1st to attempt to correct his July 28th testimony, only after he was made aware on July 28th that the Office of the Inspector General had text messages from special counsel that would likely enable the Office of Inspector General to soon learn the truth about who authorized special counsel's actions. Look, do I need to keep reading this stuff to you? The bottom line is they caught him red-handed. He lied to them. They found evidence that he was the one that did it, so that when he finds out they had his text messages, then he calls to change his story. So already he's lied to the Inspector General and to FBI investigators. That's who INSD is, I believe. Okay? He says he brought this up to Comey. Comey says, first I heard of it. I don't know what he's talking about. They go to the people, he says, in FBI leadership who knew that he authorized it. Nope. Don't know what he's talking about. We'd remember that because that'd be unusual. I mean, all I just did is I just read to you more than 2 pages of rock-solid proof that Andrew McCabe is a lying sack of horse manure. He's not going to be able to weasel his way out of this just by repeating in court, Orange Man bad. Unbelievable. That's all for this NeoUnrealist. If you want to help the channel, do me a favor. Hit like for this video. Leave a comment below. Mash down the subscribe button if you've not already subbed to the channel. Click on the notification bell beside it. Put it on the all setting if you want to keep up with newer content. If you want to contribute directly to the channel or toss your hard-earned dollars into the tip jar, follow the links below to Subscribe Star or PayPal, or if you watch this on BitChute, you can just click on the green tip pledge button on the video player. You're still around hearing this after the money-grubbing capitalist portion of the video and that long reading of an Inspector General's report written in 35 pages of legalese, you know, all just to say that Andrew McCabe is a fibber. Mark off another hash mark on your way to the die hard achievement. Thanks for watching.